has such interesting topics. We have a later section on oil and gas as energy. Here we have his topic on PG&E, which is energy, but it's also mass torts. And I'm really looking forward to this. My old friend Ed will be moderating this session. And I've really been looking forward to it in part because I've seen Ed over the years do unbelievable things in terms of valuation, like in Mirren, remember that years ago. Also, Ed has frequently been called an arsonist, so in his cases. So I really look forward to hearing him talk about the valuation of the wildfire liabilities in relation to Pacific Gas and Electric. So Ed, it's up to you.
Look, I violated a tenet, which is never follow a Puerto Rican panel. Number one, they just eat up your time with no regard for the next panel. And number two, nobody told me I could have a film that introduced the topic. You want to see a film, wildfires burning in the West Coast, beats the hell out of the beaches in Puerto Rico. Okay, not for nothing. I noticed in your book the way this panel was billed was, and I'm just sort of quoting from the last sentence, our panelists will explain how to zero in on an estimate of the damages PG&E will pay, which can be used to assess the value of the company's distressed securities. Those of you that want to sue for a refund of your tuition, line up over here because we're never going to help you zero in on the securities. Not the least of which reason is, there were a bunch of wildfires pre-petition, but there's this thing about wildfires, they happen all the time, including on a post-petition basis. And for those of us that understand the bankruptcy code, or thought we understood the bankruptcy code, I think that debt that's accumulated post-petition is entitled to administrative priority. So it's not only the wildfires, but the post-petition power outages. I forgot what the initial acronyms are, the planned power outages. Those all give rise to damages on an administrative post-petition basis. So the notion that we could ever be in a position to help you zero in on the value of securities is kind of funny. Before I go any further, let me ask the panelists to introduce themselves.
Sure. I'm Emily Slater. I'm a managing director at BURFORD Capital. We are the world's leading provider of legal finance and focusing primarily on commercial litigation in the U.S., the UK, and in other jurisdictions around the world. Prior to BURFORD, where I've been for 9 years, I was a litigator at Debevoise and Plimpton for 10 years.
I'm Phil Smyth. I'm a senior director in the corporate finance department at FITCH Group, specializing in electric, natural gas utilities, pipelines, other energy companies. And FITCH, as you know, is the third largest of the big three rating agencies, and dual headquartered in New York and London. We have about 4,500 employees, and as of 2018, fully owned by Hearst.
Arik Van Zandt, Managing Director with ALVAREZ and MARSAL's Valuation Services Group. I actually come to you from Seattle and have spent my whole life and career on the West Coast. Did my education at Stanford, so familiar with this area where all this is occurring. And in addition to my office in Seattle, I have an office in San Francisco as well, and we're actually dealing with some of these rolling blackouts and whatnot with my staff there, and just seeing some of the impacts as far as they can reach, even to our practice, beyond what's occurring obviously for the individuals who are rate holders and the people affected directly. My practice, I do distressed business valuation and expert witness work in that area, as well as personal injury, wrongful death work, assessing damages from that standpoint. So obviously a lot of topics here that are somewhat relevant to what I do on a daily basis.
Just to be clear, and I think I'm right, none of us have a stake in PG&E. None of us represent anybody. I take that back. My firm succeeded in getting conflicted out of every imaginable piece of PG&E because one of my West Coast partners, Bill Lockyer, used to be the Secretary of the Treasury of the state of California and the Attorney General of the state of California. And Bill was asked to consult the board of PG&E about its potential wildfire liability. So for the $42 that I think he earned in consultation fees, we were successfully conflicted out of all potential representation. If any of you bothered to read any of the pleadings filed in this case, and in particular the debate about whether or not PG&E ought to retain exclusivity, you know one of the standards for maintaining exclusivity is that you're involved in a large, complex case, and everyone who wants to retain exclusivity claims that theirs is large and their case is large and complex. Emily, just how large and complex a case is PG&E?
This is one of the most complex bankruptcy. I mean, we're now following the Puerto Rico panel, which has got to be the most complex one, but this is certainly one of the largest and most complex bankruptcies in recent memory. We have, the company otherwise would be solvent, but there have been, as everyone is well aware, a significant number of wildfires, and the liability in particular from the Camp Fire from 2018 drove PG&E to bankruptcy in January of this year. Just for a little bit of the scope of the potential damages, which is really the damages to various victims, fire victims, are really driving kind of where the moving pieces are around the bankruptcy. The Camp Fire in 2018 burned 150,000 acres, killed 85 people, and destroyed approximately 180,000 structures. The North Bay fires in 2017, which were the fires in and around the wine country north of San Francisco, burned 250,000 acres, killed 44, and destroyed 8,900 structures. And the Butte fires in 2015 burned about 70,000 acres, killed 2 people, and destroyed 1,000 structures. So, these are huge, massive, multi-billion-dollar liabilities. There's they think there's somewhere in between 70 and 100,000 victims that could potentially make claims against PG&E for losses. And there's 4 main groups of wildfire creditors: local governments, which have settled about $1 billion for claims for about $1 billion; subrogation claim holders, which had about $20 billion of claims. We'll talk a little bit more in a minute about the settlement they've reached. Other government entities, which have, like FEMA and CAL FIRE and other government entities, have about $7 billion of claims, and then really an unknown number of value of claims by uninsured fire victims. Right now, that's sort of hovering around 13 to 15 billion.
You should also keep in mind that separate and apart from the wildfire liability, I mean, you're talking about a company with, I think it was some 24,000 employees, 16 million customers. So certainly complex by any stretch of the imagination. To make this case even more complex, I think, as you all know, not only did the debtor very quickly after the filing, relatively quickly, file a plan of reorganization, but they were met with a competing plan of reorganization. And Emily, maybe you can speak a little bit about the competing plans and
Sure.
how that adds.
Sure. So PG&E filed a plan in September. It's been amended a couple times since then. That plan has equity holder group led by Abrams and Knighthead proposing to invest somewhere in the neighborhood of now $21 billion in new equity and $35 billion in new debt. The original plan had proposed a recovery for the wildfire victims in the neighborhood of $8.5 billion. That's now been increased to about 13.5 and $11 billion of settlement with the subrogation claim holders and $1 billion with the local government entities that I mentioned a moment ago. The court allowed, there had been a number of motions over time to lift the exclusivity. The court rejected a motion by the subrogation claim holders, but then ultimately allowed a plan led by the bondholders, led by PIMCO and Elliott, to file an alternative plan, which has creditors investing $29.2 billion of new capital to get 59% of new equity. 41% of the equity would go into a fund to pay victim claims, which they proposed about $13.5 billion for uninsured victim claims, $11 billion for the subro claims, and they would have also paid out a number of the short-term bonds at the full contract rate, and would maintain the current long-term bonds would be reinstated at the time the plan emerged. So there's two competing plans going forward, and the court ordered everybody to mediation at the end of October, and we've heard that the PG&E group has increased their offer, and there's for the victim recovery, and there's a lot of wrangling going on over how that offer should be structured, how much will be cash, how much will be equity.
Phil, maybe you can address some of the timing issues. I've read, and I think people are generally familiar with a deadline running in June for confirmation. What's the significance of that deadline?
The significance of that deadline is that it is based on legislation that was passed earlier this year. On July 12th of this year, the governor signed into law AB 1054, which in essence sets up a wildfire fund, insurance fund, to defray expenses going forward. One of the conditions to qualify for PG&E is emergence from bankruptcy by a deadline of June 30th, 2020, which will be, is quite an ambitious target. But there is mediation going on at the moment, and I think that when you look at the law in totality, it was cobbled together rather quickly. The governor took ownership of the issue and really forced it through. Up until a week or two before it was signed into law, there was serious doubt on the part of some very smart people whether or not it would get done, and in fact it was. And Gavin Newsom's been all over the state, trying to, and is very active in this bankruptcy proceeding, by the way, and has held the company to task. The upshot of the Wildfire Insurance Fund is that it gives the utilities, the investor-owned utilities in the state, including PG&E Corp, a window of opportunity to rely on this fund should there be further financial exposure, while they invest significant amounts of dollars to remediate their electric grids to reduce the risk of fires in the future. So it's very important to the state that they have 3 healthy investor-owned utilities so that they can mitigate the risk of wildfires going forward. And in addition, global climate change is an issue that is taken very, very seriously in the state. Obviously, burning up all that carbon is not good, but beyond that, in order to initiate and achieve their very ambitious clean air goals, they will need 3 strong, financially sound utilities to do that. So I'll stop there.
Just to add again to the complexity of this case, the whole notion of estimation typically takes place when you're talking about property damages, you all know, before a bankruptcy court. Once you bring in the notion of personal injury or wrongful death, that can no longer be adjudicated by an Article I bankruptcy judge. Now you need the input of an Article III judge, And in California, we've got no less than 3 different tribunals that are in one way, shape, or form involved with estimation. Arik, can you speak to which courts have what issues and why?
Yeah, and that's part of the complexity here is having these 3 different courts working with a very tight deadline to have the emergence happen by June 30th. So the Tubbs fires that occurred in 2017 are being handled in the San Francisco Superior Court. The personal injury, wrongful death, property claims are, as I just mentioned, being handled by the district court. And then all the other bankruptcy issues, including the issue of inverse condemnation, which we'll get into in some more detail, are being handled by the bankruptcy court. And this is all kind of happening, you can think about that simultaneously, right? You can't figure out what the potential damages are to add up all this potential liability on the bankruptcy side until you get all the other injury claims and things like that handled. And those trials and that process can obviously take a lot longer than what is now a June 30, 2020 deadline.
And to make matters even more interesting, the trial judge that was in charge of the Tubbs fire trial was just appointed to some higher office. So they yanked that judge out of the trial and put in a brand new judge as of, I don't know, a week or so ago. Someone mentioned inverse condemnation, which turns out to be a critical issue in the PG&E case. Emily, maybe you can give everyone a primer on what inverse condemnation is and what rulings the courts have come out with so far.
Sure. So inverse condemnation is essentially a strict liability law encoded in, it's really enshrined in California's Constitution that damage caused to property by a utility or some other railroad, other public use, must be compensated. And there has been a lot of dispute, and obviously a wildfire that's been caused by electric equipment or a tree that hits a power line and then starts a fire a company. The damage that flows from that is going to be strictly liable for those claims. PG&E, interesting, PG&E has, sorry, let me just back up for 1 second. CAL FIRE is really the investigative body that looks at fire issues around California and has determined that PG&E equipment caused all of the fires that are at issue here in 2015, 2017, 2018, except for the Tubbs fire. And so if inverse condemnation applies, they are going to be strictly liable for property and business interruption damages that are claimed against the company. To make things even more interesting, PG&E has claimed that the doctrine should not apply to it because for 2 reasons. One, that it's an investor-owned utility, and that the law was really intended for publicly owned utilities. And secondly, that the concept of inverse condemnation really flows from the idea that the damage can be sort of spread across all the ratepayers over time. And there was a recent decision in 2017 arising out of a San Diego fires in 2007, where the oversight board, the CPUC, found that San Diego they would not pass on ratepayers because it hadn't acted as a prudent actor in maintaining its power lines and the vegetation around them. And so there was a sort of a hole, and PG&E tried to argue that because it was strictly liable, it should be guaranteed being able to pass damages along to ratepayers, and now in light of the 2017 decision, they may not be able to do that, and so it shouldn't have the doctrine apply. On Wednesday, before Thanksgiving, the bankruptcy court, which had maintained jurisdiction over this, deciding whether this doctrine applied here, found in a short and pretty direct ruling that inverse condemnation does apply, that California law clearly applies and precedent clearly applies, and that there's no sense yet that PG&E may not ultimately be able to get a rate increase. So, then the court certified it for immediate appeal to the Ninth Circuit. So we'll get a decision very quickly. But a huge amount of the property damage, all of the property damage really is going to be, 100% liability will be assessed against PG&E, and there won't be any discounts on it if they are found strictly liable, which the court has said they are.
Philip, Emily talked a little bit about prudent operator as being a standard that the regulator, CPUC, uses when it makes a determination as to whether or not it can pass along to the ultimate ratepayer the cost of condemnation or the cost of making good on property damage. Can you speak a little bit about the standard of prudent operator and what that means?
Well, in the case that Emily was speaking of, the CPUC adopted a prudent manager standard, and if you look at the language around the standard, it's fairly ambiguous and subject to interpretation. And there are those, the IOUs for one, who have asserted that the standard is one of perfection, and therefore is untenable. One of the things I didn't speak to in AB 1054 is that prudence issue was one of the major things that the utilities wanted to rectify. In AB 1054, it adopts a new standard with new language that is still subject to some interpretation, but what is different is that there is a process whereby the utilities will file wildfire mitigation plans that will be approved by the state, and there will be issuance of a safety certification. Once that safety certification is issued to the utility, they are deemed prudent unless a participant to the proceedings can raise significant doubt as to their prudence, and then it would revert more towards a normal standard where they would have the burden of proof to prove that they were that they acted prudently. I just would like to jump on a couple of things that Emily discussed about the SDG&E case. It's my understanding that publicly owned, government-owned utilities have the ability to raise rates, and they can do it quickly and timely, and spread these costs over, a large group of ratepayers. In the case of investor-owned utilities, they have to go to the CPUC, and therein lies the difference, as Emily said. I just want to point out that the Witchfire, which was the subject of that 2018 ruling by the CPUC, that occurred in 2007. And it took until 2017 to adjudicate that rate case and come up with a final order. Prior to the fires in Northern California in 2017, most of these fires were in the, $2 to $3 billion range in terms of damages in the normal course of business. In 2015, there were estimates in the $10 to $15 billion range for the North Bay fires, and similar, even larger amounts for the Camp Fire. The point is, it would be impossible for these utilities to absorb those kinds of costs, whereas historically, when the costs were lower and more manageable, they were able to basically absorb those costs, socialize them. Under the strict liability, there is no negligence. They basically pay these claims out very quickly, well, relatively speaking, over the course of, 2, 3, 4 years. And, they wouldn't quibble about it. They wouldn't fight about it too much. As long as it was a reasonable payout, it would be recognized and they would pay it, as long as it was reasonable. So,
Understand, just to sort of take a step back, you're looking at competition in the PG&E case between the current shareholders on the one hand represented, as far as one can represent them, by the current management of PG&E and all of their professionals. Then you've got the Elliott PIMCO group that have hooked up with some of the victim lawyers to put in their competing plan, the concept being that if they're successful, they will own the utility on a going forward basis and will at least be able to derive that much revenue that the utility otherwise earns that isn't dedicated to paying off claims. You've got a third interest which is beginning to emerge and taking up a lot more air, so to speak, and that's the governmental interest. The governor has indicated that unless things progress more than they have to date, that he'd consider legislation to sort of take over the utility as a public utility, cut out the shareholders altogether. So you have to understand these are the dynamics that are sort of impacting progress in an already terribly complicated case. Moving on to a little bit of good news in terms of developments in the case, there are any number of large settlements that have been reached to date that certainly drive the debtor's plan, probably underscore the competing plan that are out there, and they involve what we refer to as the subrogation claims in the first instance, and then you've also got some of the governmental claims that have been resolved. And as far as subrogation, Emily, maybe you can sort of outline what the nature of the deal is and on whose behalf it was cut.
Sure. The subrogation claims are the claims by insurers that have paid out claims to underlying victims and insureds, and then they are able to make a claim against PG&E for recovery of those payouts. There were about $20 billion of subrogation claims, and they entered into an $11 billion settlement. It's about 55 cents on the dollar on their purported claims with the debtor, and that is driven by two things. One is the insurers, I think, wanting certainty, and second, there has been a very active secondary market of distressed investors buying up subrogation claims. And Baupost, I think, has been a leader in buying those claims up. I've seen some come around in the market as well that we've looked at over time. And so that has driven a lot of the, there's financial backers that are seeking to, make money. I'm sure there are people sitting in this room that are looking at or have made some of those investments, and to seek certainty and make some additional incremental recovery and gain on an investment by buying things up, relatively cheaply from the insurance companies, particularly when there was a lot more uncertainty around recovery and inverse condemnation.
Yeah, I mean, frankly, it never made sense to me that an insurance company companies paid out $20 billion to their underlying insureds. And by the way, that doesn't cover the entirety of the damages that the insureds suffered. That was just what was covered by their insurance. So if you've got a policy that covers your dwelling to the tune of $500,000, but you suffered $1 million worth of damages, you got a check for $500,000 from your carrier, and you can apply to PG&E to get the balance. But I could never understand why it is that, call it an insurance company just to make things easier, paid out $20 billion and was prepared for reasons I didn't originally understand to settle that $20 billion subrogation claim at that huge of a discount for $11 billion, until I realized that Baupost was able to buy up a lot of these subrogation claims. Again, why it was able to buy them up at what I assume was a humongous discount, and why they'd even want to, until I realized that Baupost is one of the largest PG&E shareholders. So it's a hedge on their ultimate ability to realize value from the deal. But Phil or Arik, maybe you can speak more to the justification from the insurer's perspective of why they would accept such a large discount on their subrogation claim.
Yeah, well, you know, I do a fair amount of damage analysis for insurance companies, and looking at how they approach those types of analyses and those types of claims is that, one, when the issue first arises, they're obviously assessing from the pure property perspective what's the exposure and what does this look like to pay it out. It's not until later that, of course, you get into these subrogation claims and start to really dig into where is the liability and you know, where does that liability fall, how do we prove it, and then ultimately assessing those damages from that perspective. And you know, this discount of what, 50, I think you said 50-ish, 55 cents on the dollar, it doesn't surprise me too much. I would say in the cases I've worked on, it's 60 to 70% is a number that gets paid out in the subrogation claims. Maybe a little steeper here because, like you said, this is a hedge scenario, so there's other ways to factor that in. But you know, again, it comes down to the ability to prove that liability and prove that there's damages from the liability, and then obviously assess those damages themselves. And the insurance companies just they would rather, I guess, just work through that sooner than later and understand what that is, more so than maybe getting the full payout.
I don't know, one of the reasons I guess I don't invest in insurance companies, but you know, Valpost had to buy the subrogation claim from an insurer. And one would assume, again, that Valpost was able to buy these claims at a greater discount than PG&E is ultimately paying those claims under a plan. So I still don't intuitively understand why the discount is as large as it is, but it is. There's a big debate, by the way, over the subrogation deal that got cut. And does anyone want to sort of explain what the tug of war is over whether the subrogation settlement, which sounds like a terrific settlement, on what basis might it be opposed?
There's a couple of issues going on with the subrogation settlement. One is that it's a pure cash settlement, and it doesn't pay out, and there is not clarity. It is that obviously cash is cash. It's it is the highest form. There's no risk associated with it really, and there's really moving pieces around whether the victim fund, the uninsured victim funds, will be funded entirely with cash or with equity. Both proposals today, I think, have a significant equity piece which has risk associated with it. The second major issue, and there's a litigation that's been initiated by the victims, is that arguing that the subrogation claims should be subordinated to the victim claims, and that they should not get paid out, priority first in cash and second in priority to the victims' claims. So those are the two major issues, and I think also there's, the governor has objected, the state has filed an objection. There are a number of objections that have been filed. The PG&E has sought approval of the settlement from the court, and it's still sort of sitting out there waiting for a decision. So there's a lot of controversy over this settlement. On the other hand, when we're looking at how to try to start to pull the different pieces together, and there's so many moving pieces around how this is going to settle, and how are we going to find enough capital to fund this company going forward, it's a big piece that they've gotten some certainty around. So we'll see how this continues to play out.
The thing that strikes me, and I don't want anybody quoting me to say that this is the fault of the lawyers, but this is probably the fault of the lawyers. And I don't mean all lawyers. Certainly, I wouldn't disparage bankruptcy lawyers. It's those personal injury lawyers that work on a contingency fee basis. Guess what? Those lawyers don't want to get compensated in the form of stock or in the form of notes, even notes that are going to get underwritten by some of the biggest and best underwriters in the world. They want cash. And I think what they are concerned about is there's only going to be so much cash to go around. There'll be cash, there'll be notes, there'll be stock. They want to get paid in cash. And to the extent that a lot of cash is going to go to settle the subrogation claim, I think, and this is just me pontificating. I think they think there's that much less cash to go to their victims and to be available to pay their enormous, outrageous, unconscionable, I didn't say that, contingency fee. And I think that's part of the issue. It's gotten so complex and convoluted that, and you see these arguments crop up every once in a while, the extent to which the subrogation claimants are entitled to vote on a plan. And we all know, those of us that are the lawyers in the room as opposed to the bankers don't care one way or the other, but the lawyers know that in order to vote on a plan, you have to be impaired. So the argument is that you settled your $20 billion claim like a moron for $11 billion. You're going to get your $11 billion. You got everything you otherwise were entitled to. Therefore, you're unimpaired under the plan once your settlement gets approved. And the way they structured this is the settlement gets approved outside of confirmation. It doesn't get implemented until confirmation, but you're settled by virtue of a court order that approves the settlement. At that point, you're not entitled to anything other than the fruits of your settlement. And if you get that, you're not truly impaired. So the question will even go to whether or not the subrogation claimants, once settled, are going to be permitted to vote one way or the other on the plan itself. What other settlements underscore the plan so far? Philip or Arik?
Well, we have, for other government groups that were handling various aspects of cleanup and providing resources for the victims, $1 billion for local government that's part of the settlement process so far. And another issue here is going to be FEMA. You know, and FEMA is uniquely situated here, and I think the parallel that I'm drawing with this is like the BP oil spills of the Gulf, where instead of FEMA coming in with a normal natural disaster type situation where there's no one at fault, there's no liability attached to a party, in the BP oil spills you had that. And FEMA did make requests for payment, or demands for payment rather, back to BP for the resources it put into play. And we have that same situation here too. So FEMA immediately put resource shelters and things in place for these fire victims, I think to the tune of, do you know the number on that?
So I think altogether it's like
$7 billion.
$7 billion.
$7 billion of money that's, for all
Across
all fires so
yeah.
far. And so they are making a claim to PG&E for that money to be recovered, which again, fairly unique from a FEMA perspective, given the normal course of how they get involved.
Yeah. I got the sense that they were a little surprised when that claim came in at the end.
Yeah.
I think it also includes the OES also.
That's
and,
right.
Yeah.
Yeah,
It's
and
not
CAL
all
FIRE.
FEMA. It's OES, also CAL FIRE's a few dollars in there, but you would expect CAL FIRE to
Yep.
recover those costs.
So anyway, for those of us that have done claims estimations, be it in a bankruptcy court, if all you're talking about is property damage, or be it in a district court when you start dealing with personal injury or wrongful death, you start saying to yourself, how difficult can this be? I mean, a life is a life. You ought to be able to put a price tag on it, right? And it ought to be pretty simple.
And it can be, or it can be more complex. And a lot of this is going to come down to discovery as well. And I actually worked on the defense side for it was the largest landslide that we've had in the United States. It was 43 deaths, number of injuries, obviously a lot of property loss, things like that. And there was liability attached to a company that had done clear cutting, the company that actually built this community in an area that was susceptible to the flood and to the landslide itself. And in that case, settled for about $60 million. And again, that's 43 deaths as opposed to what we're looking at here, which is 130 plus, obviously a number of injured. So to see these numbers up in the billions range as it is does seem a little steep. But I know we're dealing with a lot of high value property, the structures themselves that were damaged within the wine country, Marin County, where Santa Rosa and where a lot of these fires occurred. It's very valuable property. But you're right, on the life side, it can be fairly straightforward, but we're talking about an entire community here. And this is people from all different walks of life, business owners, so you maybe have loss of business or interruption from business. Emily and I were talking this morning about how far this could spread. You have supplier issues, you have customer issues that are interrupting businesses as well, and how far can that economic damage spread when you start to factor in all the other elements of economic damages that occur because of a localized event like these fires.
But are you suggesting that a house in Malibu might be worth a larger claim than a house in Culver City? Is that the way it works?
Well, it's about the fair market value of the property that was damaged, just like it's the fair market value of the economic loss to the individual, whether they're injured or from a wrongful death perspective.
And is it the same concept when you value someone's life, the fair market value of a life?
It's different, right? So if you have an individual that had a greater earning capacity and need to factor in consumption, need to factor in other aspects of how they contribute to their estate, then they are different from individual to individual, absolutely.
I've begun to see like a list in a couple different places of the kinds of losses that people are dealing with in terms of claims. And understand that the bar date in this case was originally set, I forgot when, but
October 21st.
October.
it's now been extended through the end of the year because of concerns about whether or not people understood that they had a deadline to file claims and what those claims consisted of. But when you think about the nature of the losses, I've seen debates going both ways about claims for emotional distress. And I joked about not being given the opportunity to do my own movie like the Puerto Rican panel did. But you've all seen the movies on the news where people are driving through wildfires, and you can imagine that they suffered not a small amount of emotional distress. Well, first of all, how do you categorize emotional distress? Is it a personal injury? Is it related to property damage, which is only relevant if you have to worry about which court is going to do the estimation? But is it a cognizable claim in the first place? And how does one go about estimating the value of emotional distress?
And I think that's part of the complexity of the timing here too, with this June 30, 2020 deadline, because this can be something that's handled through various medical experts, and they can determine those cognitive changes and whatnot, and potentially even something as grand as a life care plan might be needed to really get people back to their standard point before, so that they can fully mitigate any further damages. And those processes take time. I was involved in a trial that was 4 months long that involved it was a mass casualty case, and it was a 4-month trial. Because you had to work through medical experts, economic experts, damage reconstruction experts, all that stuff, and it's a long process. But it can obviously be measured in certain ways. You just need to have a lot of people involved, a lot of experts involved to get you there.
Yeah, for those of us that have had some involvement in asbestos-related Chapter 11 cases, you're familiar with the fact that there are entire categories of claims called fear of cancer that some courts of competent jurisdiction recognize, and they're part of the calculus that go into the estimation of overall damages.
Yeah. I just wanted to jump in and just, they're sort of the personal injury claims and emotional distress and potentially punitive damage claims, claims other than just pure property damage claims that are sort of covered by the inverse condemnation claims. Those all sound in negligence. So the sort of, those are going, and PG&E is contesting whether it was negligent in all of the fires. And so there not only has to be a damages estimation process, but a court has to go through each of the fires and make a determination on how negligent PG&E was, and there will be a risk discount ultimately applied to the damages, from aggregate damages from each fire.
Well, maybe not.
Maybe.
Again, PG&E's position when they filed was they were a solvent company, and that they were paying their claims in full. And that gives rise to certain conclusions about whether or not you're liable for things like punitive damages. In a situation where the company doesn't have the wherewithal to pay 100% of its liabilities, the notion that punitive damages would come before compensatory damages is pretty well settled, that everyone needs to realize the benefit of their compensatory damages before any punitive damages are ever assessed. And the whole notion of inverse condemnation and the sort of strict liability on a no-fault basis suggests to me, at least, that I don't know that we're ever going to get to punitives that are predicated on just how liable or negligent PG&E might have been, but it's just yet another element of complexity. Not to suggest that the entire case is driven by personal injury or property damage resulting from the fires. Give you another one that makes this case awfully complex. You've got, I think it was $17 billion worth of unsecured bond debt in the case. And PG&E touts the fact that it's going to be able to issue brand new paper to satisfy that $17 billion worth of liability at much better rates, because the market rate on the bonds has dropped dramatically. So you think everybody's happy. We're going to get brand new pieces of paper, albeit at a lower interest rate, to take care of the high interest debt that we had. But for the fact that the bondholders now claim a make-whole entitlement, which is no small bit of change in PG&E. I think it's a $5 billion issue. And that will depend on some court's interpretation of the indentures, and the same court's interpretation of whether or not, you had a bankruptcy-related default that makes the make-whole provision, if it's in the indenture, enforceable. So plenty of issues of complexity yet to be considered and yet to be resolved, not the least of which is, as we mentioned before, you've had a bunch of fires post-petition. You've had a bunch of claims that are going to be asserted based on power outages that were planned power outages to avoid even more egregious potential fires. So I think we've come close to exhausting our time, and I don't want to make up for Puerto Rico's piggishness by running into everybody else's time. So questions, comments, concerns? See how well we covered every conceivable issue. No one has a question left. Oops.
Someone had to.
Hi, thanks for the panel. Would you expect that the victims get an opportunity to vote on this plan, just like in asbestos case?
Well, the complexity associated with victim voting is astronomical. Think about it. It's one thing to solicit individual proofs of claim from the thousands of potential victims. It's possible that the court will allow a class claim and may even allow class claims as part of the estimation procedure. So to the extent possible and consistent with federal rules of evidence, mostly Rule 23, may or may not permit for estimation based on class-wide, proofs. When it comes down to voting, first of all, the votes can't be solicited without an approved disclosure statement that's got to be written in such a fashion one would think to be cognizable by your typical victim. And then you've got to go out and solicit the votes, and then you got to tabulate the votes. And it's yet to be seen how the judge is ultimately going to deal with allowing individual votes versus class votes versus, collective votes.
Thanks.
Hi, Richard Fells. This question also applies to Puerto Rico. When the deal is done, is there ever a look back of the lack of capital spending that the California utilities are foregoing now? I mean, they've always been in the forefront, but is there anything in the plan that would create a separate bucket of funds so that they can get ahead with the next generation of power generation?
Well, again, it depends on, Donald Trump thinks the biggest problem is that you forgot to rake the leaves, and that's where the wildfires came from. The answer is I don't know what the plan provides for.
I can address it, but not within. I don't think it's something that will be addressed in the bankruptcy court proceeding itself. But the legislation that was passed does address that very issue. The three utilities are required under that law to participate in that wildfire insurance fund to invest $5 billion that will be absorbed by shareholders when they come out. So, well, when PG&E comes out, and the others will absorb it as we go forward in time. But just to put some brackets around it, PG&E is investing about $7 billion in CapEx on an annual run rate. So it's not like they're not spending money; they are. But it's a very old utility. It's a very old transmission and distribution system, and they're going to be upping their game when it comes to replacing that infrastructure and hardening it so that this doesn't happen going forward. And I've seen some of the things they're doing, and it's pretty impressive. They're covering conductors, i.e. transmission lines, distribution lines, with a surface so that when Mylar balloons blow into them or trees, hopefully it won't cause sparks to fall down and cause fires in the underlying vegetation. They have emergency operating centers, much improved communications with local authorities. They have meteorological centers, state-of-the-art stuff, cameras. They use all this data from this emergency center to communicate with local civil authorities to, try to, if there is a fire, to respond to it more quickly. And this is something that San Diego Gas and Electric started doing in '07. And so now all of the utilities are doing it in earnest.
And some of it was pretty basic stuff that wasn't being done. Trimming trees that are all around the power lines and whatnot, they were way behind on that. And that's really where a lot of this came from. Not using wood telephone pole or power poles, things like that. But others, from this CapEx perspective, is going to be more high tech. It's the communication directly from the transmission lines back to the company, so they can understand where these certain things are occurring, respond more quickly, understand where some of the problems are going to be occurring on the grid itself. But they were behind, obviously. And so on a go-forward basis, there's going to be a big catch-up, but there's also a forced catch-up to be the prudent operator.
Hi, thank you for the panel. This question may be more for Arik, but I'll open it up to the whole panel. Regarding the subrogation claims that were sold to Baupost, I sort of wonder if it was because the insurance companies reserved for the loss, paid out $20 billion, maybe they reserved and thought it was going to be 25, 30, paid that out, was happy to get any sort of subrogation value and certainty to that, and then sort of walk away from the disaster. In your experience, has that been sort of an approach insurance companies take? They have a loss, they reserve for it, and they just want to sort of, kind of move on.
I think the concept of moving on is absolutely part of it. Insurance companies don't want to be drugged through these types of processes. It costs money to fight these as well. You have to hire attorneys and your experts and things like that to get through the process. So yeah, I mean, the experience for me is that they would like to get that amount, again, and my experience has been more 60-70% payback as soon as possible and not worry about the drag-on effects. Yeah.
Yes, sir.
Hey, thank you for doing this. I know you talked about it a bit already, but wanted to see if you could unpack further how a fire settlement could possibly unfold in a way that binds individuals who have a right to litigate an unknown amount of claims. I mean, it's sort of like you can compare it to Puerto Rico with the GOs. You can, save for the future that litigation, but you can reserve for it. Here, how do you You know, do you run through
it's a good
estimation and force it on people?
It's a good question.
You don't have asbestos law.
The estimation typically is done for two separate and distinct purposes. One is to make reserves under a plan so that you conceivably know what your financing needs are, both in terms of raising debt and raising equity, so as to be able to meet your feasibility challenges under a plan. Separate and apart from that is the question of what is any individual entitled to by way of a distribution. And I think conceptually, the way I understand PG&E is viewing this is it wants to do the estimation for purposes of the former, not the latter. You can only achieve the latter doing an estimation for purposes of what people are going to ultimately receive if people voluntarily give up their trial rights. Now, that's a lot harder to do for someone to give up their trial rights if you're talking about personal injury and wrongful death. It's a little bit easier, although by no means a slam dunk, to do it with regard to property damage. But therein lies a distinction. We've all seen in the asbestos arena or in other mass torts, what you basically come up with once you've figured out how much money you have to set aside in a trust, you then have trust distribution mechanisms on how people are ultimately going to access the funds that are in the trust. And to the extent that people will waive their jury trial rights, you get on an expedited track and conceivably will get more money out of the trust. So you're incentivized to waive your jury trial rights. And to the extent that you refuse to waive your jury trial rights, understand it could also impact everyone else's distribution. If 10 of us are all claimants within a fixed fund, cap fund, even if I'm prepared to waive my jury trial rights in order to get a quick settlement, I don't know how much of the fund I'm going to be entitled to till Emily finishes prosecuting, her jury trial right, because she may ultimately get an award that suggests that, my pro rata distribution isn't available because some amount has to be set aside for her claim. So I know I didn't answer your question other than to tell you that the estimation that PG&E is looking for is for purposes of figuring out financing, how much it has to raise, feasibility. The ultimate distribution is going to be subject to, I would presume, some complex post-petition administered trust advisory distribution mechanism. And again, not to disparage lawyers, but all this stuff is driven by contingency fee lawyers that want to make sure there's enough cash available for their recovery and thinking that they may do better in a trial than just taking their cut of the fund.
So, Ed, under the code, if you have a pre-petition claim and you don't file a claim, do you then waive the right to bring a claim?
Yes.
Any claim, not just in the fund, but also a personal injury claim against the company, right?
Yes. I mean, unless, assuming that you were afforded due process in connection with the establishment of the bar date. And I know I saw Kristen Going here a little while ago, who has the nerve to represent the General Motors trust that was established as part of the plan against the poor victims that I represent who realized property damages because of these busted ignition switches. We were never given any notice of the bar date, even though GM knew they were selling a defective car. It's now been established that if your due process rights were violated, the bar date's not applicable, and you can come in and file a late claim. But yes, other than situation, thank you, where your due process rights may have been violated, the failure to file a claim means that you've lost your entitlement to get in line, either now or any time in the future.
So I mean, especially for the victims of the campfire, ordinarily, obviously, someone would have several years to bring a personal injury claim or damage claim, and so you've got people with a bar date within a year. People are scattered to the wind. How many people are ultimately going to file a claim is another huge piece of unknown in terms of what the full amount of recoveries are going to have to be paid out.
There's also an entire line of case law that speaks to the issue of late claims. So in situations where people are scattered to the wind, they're living in FEMA trailers, they're not watching the TV or getting a newspaper delivery to find out that there's an effective bar date, they may have excusable neglect where their claims to be filed past the bar date.
I want to spare you from having to go into GM now, but thanks a lot. And we have, I think, about 15-minute break. You can talk to people during it, and then we'll be back for the oil and gas seminar.
Sounds great. Thanks.